Roll call for Legislative Day 26, Thursday, March 25th. Anderson. Here. Baldwin. Here. Beitman. Here. Boner. Here.
I got it.
Bouchard. Here. Case.
Present.
Cooper.
Here.
Driscoll. Ellis. French.
Here.
Murphy. Baru. Hicks.
Here.
Hutchings.
Here.
James.
Here.
Kinski.
Here.
Cole.
Present.
Cost. Landon. McEwen. Nethercott. Pappas. Perkins.
Here.
Rothfuss.
Here.
Salazar. Schuler. Scott.
Here.
Steinmetz. Wasserberger. President Dockstader.
Here.
Driscoll, excused, Mr. President, excused. Oh. Driscoll. Driscoll present, 30 present.
Prayer by Reverend Mark Marston.
Let us pray. Our Lord above, creator of all we have, all we will ever have, we come on this day and we stand on the shoulders of giants who have occupied this space long before us, visionaries who have seen beyond their years here in Wyoming and have seen Wyoming for all its grandeur, a brighter, freer, more just and godly land than it was when they walked into this chamber. Our Lord, may these men and women who have been called to this same vision be blessed, that they too may live beyond their years, that they might make decisions to make this wonderful place more blessed, more godly, a more wonderful Wyoming. For these things we pray in Jesus Christ. Amen and amen.
Senator Ellis, would you start us in the pledge?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice.
Reading correction approval of the journal. Will the reading clerk please read the journal committee report?
Mr. President, your committee reports that the Journal of March 24, 2021 has been read and recommends that it be approved. Senator Cole, Chairman.
Any objections? There being none, the report is adopted. Thank you to Reverend Marston for helping us with a prayer from First United Methodist Church here in Cheyenne. Today in Wyoming history, in 1915, Arminto, Wyoming was incorporated. Who can tell me where Arminto is? Senator Anderson. Yeah, sorry, you got Senator Case, you got to follow up?
You can go from Highland over to Arminto and get to KC. And the whole New Wall's back in there.
So from light side, okay. A little bit more information. Arminto was a major sheep shipping point at one time. More sheep were shipped from its stockyards where they were loaded into trains than from any other place in the world. Today, with the decline of the American sheep industry, Arminto is nearly a ghost town with just a few remaining residents. The town's once busy railhead is now just a rail crossing. Its post office closed in 1964. Quote from the day, Ellen Johnson Sirleaf, "If your dreams do not scare you, they are not big enough." All right. Messages from the House.
From the House of Representatives, March 24, 2021. Mr. President, the following bills passed the House in an amended form. Message number 273, House Bill 51, Meat Processing Programs, ayes 56, noes 4. Message number 274, House Bill 155, Electric Generation, Reliability and Liability, ayes 50, noes 10. Message number 275, House Bill 159, Liquor Manufacturer Regulations, ayes 48, noes 12. Message number 276, House Bill 161, Human Life Equality Prohibiting Discriminatory Abortions. Ayes 53, noes 7. Message number 277, House Bill 189, Mine Product Taxes for Natural Gas Consumed on Site. Ayes 31, noes 28. Message number 278, House Bill 195, Wyoming Medical Review Panel repeal. Ayes 53, noes 7. Message number 279, House Bill 210, Minor Sex Traffic Victims Liability. Ayes 59, noes 1. Message number 280, House Bill number 231, College Credit Retention. Ayes 60. Message number 281, House Bill 239, Workers' Compensation Student Learner Agreements. Ayes 59, noes 1. Message number 282, House Bill 244, State Investment Administration. Ayes 43, noes 17. Message number 284, House Bill 245, Transportation Computer System. Ayes 48, noes 12. Message number 285, House Joint Resolution 13, Support of Taiwan. Ayes 60. Message number 286, House Bill 36, Management Council Membership. Ayes 51, noes 9. Message number 287, House Bill 127, Public Health Amendments. Ayes 58, noes 2. Message number 288, House Bill 157, Healthcare Professional Education Endowment. Ayes 34, noes 26. Message number 289, House Bill 162, Medical Treatment Opportunity Act. Ayes 32, noes 28. Message number 290, House Bill 219, Investment Funds Committee Membership. Ayes 40, noes 19, excused 1. Message number 291, House Bill 253, University of Wyoming ban on funding for abortions. Ayes 48, noes 11, excused 1. Message number 292, House Bill 263, State Coronavirus Recovery Funding. Ayes 43, noes 16, excused 1. Signed, Wendy Harding, House Chief Clerk. March 24, 2021. Mr. President, the following bill failed to pass the House on third reading. House Bill, message number 283, House Bill number 247, ayes 20, noes 40. March 24, 2021, message number 293. Mr. President, having passed a motion to reconsider House Bill number 247, Law Enforcement Hiring Practices, passed the House on third reading in an amended form. Ayes 31, noes 24, excused 5. Signed, Wendy Harding, House Chief Clerk.
Reports from standing committees.
March 24, 2021. Mr. President, to committee number 2, appropriations, to whom was referred House Bill 10, engrossed COVID-19 Large Business Relief Program, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes Senators Guru, Hicks, Perkins, and Steinmetz. Excused Senator Kinski. Senator Perkins, Chairman. March 24, 2021, Mr. President, to committee number 1, Judiciary, to whom was referred House Bill 193, engrossed County Attorney's Representation of Special Districts, respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Cooper, French, and Cost. No Senators Kolb and Nethercott. Senator Nethercott, Chairman. March 24, 2021, Mr. President, to committee number 1, Judiciary, to whom was referred House Bill 116, Concealed Carry Residency Requirement 2, respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. March 24, 2021, Mr. President, to committee number 2, appropriations, to whom was referred House Bill 17, engrossed range management at military training areas, respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Guru, Hicks, Kinski, Perkins, and Steinmetz. Senator Perkins, Chairman. March 24, 2021, Mr. President, to committee number 9, Minerals, Business, and Economic Development, to whom was referred House Bill 207, engrossed coal-fired generation facility closures, litigation funding, respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Anderson, Whiteman, and Cooper. No, Senator Rothfuss. Excuse, Senator Wasserberger. Senator Anderson, Chairman. March 25, 2021. Mr. President, your committee number 2, Appropriations, to whom is referred House Joint Resolution 3, engrossed, State Lands Mineral Royalties Constitutional Amendment, respectfully reports same back to the Senate with the recommendation that it do not pass. Ayes, Senators Hicks, Perkins, and Steinmetz. Noes, Senators Garou and Kinski. Senator Perkins, Chairman. March 24, 2021, Mr. President, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 144, Electric Vehicle Fee Updates, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Furphy, Landon, McEwen, and Pappas. Senator Pappas, acting chairman.
Bills on second reading. Senator Anderson.
Mr. President, we just read in House Bill 207. It has an appropriation. I would ask that it be re-referred to appropriations. Thank you.
Absent objection, House Bill 207 referred to Committee to Appropriations. Thank you, Senator. Senator Driscoll.
Mr. President, I have a series of 4 re-referrals. I'm going to read them in together.
Let's do them one at a time.
Okay. Mr. President, I would ask for re-referral of House Journal 9, Local Government Investments and Equities, from Corporation 7 to Corporation 1, Judiciary.
Okay, House Joint Resolution, what was the number again, sir?
9.
9. Absent objection. Mr. Chairman, have these been formally read in from your committee yet?
They have been.
They have not?
They have been. They're actually posted on the calendar and we ran over. And
We're-
we're asking to move some bills so that we don't kill some house files.
Understood. Let's just double check.
They're actually on the calendar for tonight.
Sir, we haven't got a 9. Could you go to the next one?
House Journal 11, State Sovereignty Impacted by Federal Actions.
Sorry, sir, keep going.
What's that?
Well, that has not been read in.
Okay, I'll come later. I'll come see Chief.
Yeah,
Clerk.
let's double check.
They're
the-
actually on the calendar for tonight on my committee.
Okay, we got a little discrepancy in record.
I'll stand down.
All right, Senator, during the next break, would you visit with the chief clerk?
I will.
Thank you.
President.
All right. Bills on second reading. House Bill 14, second reading of the House Bill.
House Bill 14, Rights of Way Along Public Ways Amendments.
There are no amendments. House Bill 14, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 21, second reading of the House Bill.
House Bill 21, Wyoming National Guard Preference for Education.
House Bill 21, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Oh, Senator McEwen.
Mr. President, I'd like to lay House Bill 22 back one day, please.
That's the next one, sir. We're on 21 now.
Yes,
So
sir.
give me just a moment on that, okay? House Bill 21, having been read 2 separate times, the question is, shall the bill be read a third time? Having no objection, it is so ordered. House Bill 22. Second reading of the House Bill.
House Bill 22, Wyoming Military Code.
Senator McEwen.
Mr. President, I'd like to lay House Bill 22 back for one day.
Absent objection, House Bill 22 laid back for one day. Thank you, Senator. House Bill 39, second reading of the House Bill.
House Bill 39, Optometrist Practice Act Amendments.
There are no amendments. House Bill 39 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 52, second reading of the House Bill.
House Bill 52, Wyoming School Protein Enhancement Project.
There are no amendments. House Bill 52 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 109, second reading of the House Bill.
House Bill 109, Local Health Officers Education Requirements.
House Bill 109, there are no amendments. House Bill 109 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 122, second reading of the House Bill.
House Bill 122, Hunting and Fishing Access Reliable Funding.
House Bill 122, there are amendments. Please read in the amendment.
House Bill 122, second reading amendment number 1 to engrossed copy, page 2, line 13, delete.
Thank you. Senator Hicks.
Mr. President, I move second reading amendment number 1 to House Bill 122 and ask for your favorable consideration. Members of the Senate, this just brings in some conforming language to the existing statutes in 23-1501, and there was one omission in there, which included private land, and the rest of it's just cleanup language to reflect the existing statutory language under that provision. Ask for your favorable consideration.
Discussion or questions on the amendment. Senator Baldwin.
Yes, Mr. President, thank you. This is a friendly amendment, and I would encourage an aye vote on it.
Ready for the question? Question being called on second reading amendment number 1 to House Bill 122. All those in favor say aye. Those opposed, nay. The amendment has passed. Back on the bill. House Bill 122 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. House Bill 135, second reading of the House Bill.
House Bill 135, Hank Cole Leadership Highway Designation.
Senator Driscoll.
I would ask that House Bill 135 be laid back one day.
Absent objection, 135 is laid back one day. House Bill 148, second reading of the House Bill.
House Bill 148, Fees Paid to Secretary of State Amendments.
House Bill 148, there are no amendments. House Bill 148 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Bills on third reading and final passage. Mr. Majority Floor Leader, do you have a consent list?
Mr. President, we do have a consent list. I move that the, move for adoption, move the Senate. Yeah. Move for adoption of the following bills on third reading. House Bill number 4, Mental Health Professions Practice Act Amendments. House Bill 20, Driver's License Requirements, Visual Acuity. House Bill 29, Burials for Indigent Persons. House Bill 33, Interference with Public Contracting. House Bill 49, Agency Fee Revisions. House Bill 54, Wyoming Meatpacking Initiative. House Bill 57, Advanced Enrollment. House Bill 69, Division of Banking Fees. House Bill 76, Uniform Statewide Payment Processing. House Bill 86, Off-Road Recreational Vehicles Registration Authorized. House Bill 87, Provider Recruitment Grant Program. House Bill 91, Removable of Unenforceable Property Covenants. House Bill 111, Access to Anatomical Gifts and Organ Transplants. House Bill 118, Food Freedom Act Amendments. House Bill 120, Hathaway Scholarships, Success Curriculum in Middle School.
Would anyone like any of these bills removed from the consent list? Senator Rothfuss.
Thank you, Mr. President. Mr. President, I'd request that House Bill 76, Uniform Statewide Payment Processing, be removed from the consent list.
Absent objection, 76 has been removed from the consent list. Senator Perkins.
Thank you, Mr. President. I don't have, if I may have privilege of the floor for just a second.
Please do.
Thank you, Mr. President. I don't, on House Bill 54, Wyoming Meatpacking Initiative, I don't own an interest in any meatpacking plant. However, I do actively represent someone who has, represent an active meatpacking activity that may benefit from this. And this is such a small population that I feel I need to declare a conflict on that. So I just want to declare that now. So when we go through the amendment, I will declare a conflict.
Declare
Thank you.
conflict. And Senator, would you repeat that House bill again, please?
It'd be House, I'll do it on House Bill 54.
Thank you, sir. Any further removals? All right. Having been read 3 separate times, the question is, shall these bills pass the Senate? House Bill 4, Mental Health Professions Practice Act Amendments. House Bill 20, Driver's License Requirements Visual Acuity. House Bill 29, Burials for Indigent Persons. House Bill 33, Interference with Public Contracting. House Bill 49, Agency Fee Revisions. House Bill 54, Wyoming Meat Packing Initiative. House Bill 57, Advance Enrollment. House Bill 69, Division of Banking Fees. House Bill 86, Off-Road Recreational Vehicles Registration Authorized. House Bill 87, Provider Recruitment Grant Program. House Bill 91, Removal of Unenforceable Property Covenants. House Bill 111, Access to Anatomical Gifts and Organ Transplants. House Bill 118, Food Freedom Act Amendments. House Bill 120, Hathaway Scholarship Success Curriculum in Middle School. And these bills having been read 3 separate times, the chief clerk will call the roll.
On the consent list, Anderson, Baldwin, Bateman, Boner, Bouchard, Case, Cooper, Driscoll,
Aye.
Ellis, French,
Aye.
Murphy, Guru, Hicks, Hutchings, James, Pinsky, Kolb, Cost, Landon, McEwen, Nethercott, Pappas, Perkins,
Aye.
Rothfuss,
Aye.
Salazar, Schuler, Scott, Steinmetz, Wasserberger, President Dockstader. On the consent list, 30 aye. House Bill 4, are there any changes? Closing vote. Closing vote closed. House Bill 4, 30 aye. House Bill 20, are there any changes? Case, aye to no. Scott, aye to no. Hutchings, aye to no. Closing vote. Closing vote closed. House Bill 20, 27 aye, 3 no. House Bill 29, are there any changes? Closing vote. Closing vote closed. House Bill 29, 30 aye. House Bill 33, are there any changes? Closing vote. Closing vote closed. House Bill 33, 30 aye. House Bill 49, are there any changes? Bateman, aye to no. Salazar, aye to no. McEwen, aye to no. Hutchings, aye to no. Bouchard, aye to no. Case, aye to no.
French, aye to no.
French, aye to no. James, no. Closing vote. Closing vote closed. Senate House Bill 49, 22 aye, 8 no. House Bill 54, are there any changes? Beitman, no. Bouchard, no. Case, no. James, no. Scott, conflict, confirmed. Steinmetz, conflict, confirmed. Perkins, conflict, confirmed. McEwen, no. Closing vote. Closing. Vote closed. House Bill 54, 22 aye, 5 no, 3 conflict. House Bill 57, are there any changes? Closing vote. Closing. Vote closed. House Bill 57, 30 aye. House Bill 69, are there any changes? Closing vote. Closing. Vote closed. House Bill 69, 30 aye. House Bill 86, are there any changes? Hicks? Aye to no. Kinsky? Aye to no. McEwen? Aye to no. Closing vote. Closing. Vote closed. House Bill 86, 27 aye, 3 no. House Bill 87, are there any changes? Closing vote. Closing. Vote closed. House Bill 87, 30 aye. House Bill 91. Hicks, aye to no. Hutchings, aye to no. Cooper, aye to no. Kinsky, aye to no. Perkins, aye to no. I'm sorry, Kolb, aye to no. Closing vote. Closing. Vote closed. House Bill 91, 24 aye, 6 no. House Bill 111, are there any changes? Closing vote. Closing. Vote closed. House Bill 111, 30 aye. House Bill 118, are there any changes? Closing vote. Closing. Vote closed. House Bill 118, 30 aye. House Bill 120, are there any changes? Closing vote. Closing. Vote closed. House Bill 120, 30 aye.
Having received the affirmative vote of the majority of the members elected to the Senate, House Bill 4, Mental Health Professions Practice Act amendments. House Bill 20, driver's license requirements, visual acuity. House Bill 29, burials for indigent persons. House Bill 33, interference with public contracting. House Bill 49, agency fee revisions. House Bill 54, Wyoming Meat Packing Initiative. House Bill 57, advanced enrollment. House Bill 69, division of banking fees. House Bill 86, off-road recreational vehicles registration authorized. House Bill 87, provider recruitment grant program. House Bill 91, removal of unenforceable property covenants. House Bill 111, access to autonomous gifts and organ transplants. House Bill 118, Food Freedom Act amendments. House Bill 120, Hathaway Scholarship Success Curriculum in Middle School have passed the Senate. Bills on third reading. House Bill 7, Air Ambulance Membership Organizations Regulation. There is an amendment.
House Bill 7, third reading amendment number 1 to engrossed copy, corrected copy, delete.
Could we also have you read or repeat the bill number and the name of the bill as well?
House Bill 7, Air Ambulance Membership Organizations Regulation, sponsored by the Minerals Committee, an act relating to insurance.
And there is an amendment. Let's go to Senator Case.
Yes, Mr. Chairman, I move third reading amendment number 1 to House Bill 7. Mr. President, what this does is goes into the standing committee that we approved on first reading, and it removes the standing committee amendment and then reinstalls some of the part of the standing committee amendment. The purpose of what I'm trying to do here is, I think the standing committee, it's kind of an upon reflection thing, and is looking at what the standing committee did. And what was of concern was 2 requirements that the insurance companies or the insurance commissioner evaluate these companies with respect to their solvency, their financial capability, on and on, like an insurance company. And I want to say that upon really thinking about it, I think that's improper and inappropriate. What we're talking about, Mr. President, are memberships that'll take you out on an air ambulance. They're $25 a month memberships. If the company goes out of business, you don't have to pay your $25 anymore, Mr. President, and they're not going to fly you out. This is not the same as an insurance standard, where if you've paid premiums, you want to make sure that the company can deliver and pay off the premiums, say on your house or your life or other claims. It's an improper reach, I think, when you really think about it. And we've heard from folks that had been supporting the bill before that were in this industry and have now had pulled out because of this requirement. Secondly, we heard about a pending case, I guess it's gone to the Supreme Court in a state that was on this exact issue. Can we regulate the air transport? And the case at least indicates that we can't. So what my amendment does, and my good co-sponsor, we go in and we look at some disclosure that was supported by everyone and was brought by an organization that represents old people like me. And we made sure that that was retained in the standing committee amendment. And that is the language that you see here. And I'm happy to answer any questions. But really, I think if you think about this, the financial standard test is not appropriate, because if an air ambulance company goes out of business and can't deliver the goods, you don't have to pay the membership. And it kind of resolves itself. Thank you very much, Mr. President. Happy to answer any questions.
Questions and discussion for the sponsor. Senator Nethercott.
Thank you, Mr. President. On and against the amendment. Good senators, I'm going to need you to follow with me carefully here, because I'm going to be kind of inconsistently providing information. One, I believe the bill in and of itself is unlawful, relating to that opinion that the good senator referenced. The Eighth Circuit this past week issued an opinion that indicated that really states can't regulate air service. And the reason for that is federal nullification issues, that the federal law trumps any state ability to do so. Quite clear for air service issues and other issues as well. And so really important, but that Eighth Circuit opinion related to this industry very, very specifically, this exact same or similar scenario occurring in our sister states. But I'm on and against the amendment because regardless, well, not regardless, but even in lieu of that particular piece, I'm going to ask you to vote no on the bill, but against this amendment, because if the bill passes, I want to make sure the amendment stays in. And so that's what I'm driving at here. Those consumer protection pieces are critically important and actually that are found in the standing committee amendment. They're the reason why the bill was brought forth. They're the reason why there's been successive litigations in our surrounding states and will be in our state and will continue to be, is as a result of some of these air ambulance service companies are providing good services to the people of Wyoming that are necessary for our rural communities and that save lives. Some of the air ambulance service companies are less credible and are really doing a pretty, I think, dangerous enterprise for the consumers of this state. And so what happened in our sister state and what triggered some of the litigation there was that they tried to regulate the concept associated with return billing. And so if they had to dispatch an air ambulance that wasn't in the service member's provider, even though you had the card, you still got with the tens of thousands of dollars in compensation owed to you. And sometimes, frequently, what we're also seeing with these air ambulance companies is that they're multiple subsidiaries, and that's always troubling when there's these multiple subsidiaries. And the reasons for multiple subsidiaries is to spread the liability in a much smaller pool. And so if one of the smaller corporations gets sued or goes bankrupt, it doesn't affect the larger pieces. And that's not good for consumers, but it is how they're structured. So this consumer protection issue is vital. It's not that I don't support the need for air ambulance services in this state. We 100% need those. It's critical. I grew up in rural Wyoming. I certainly understand that. It's that we need to have reliable, incredible, and reputable businesses operating and providing such an important service in this state. So the amendment actually sought to do that and seeks to do that. So on and against the amendment, we need those protections to protect the citizens of Wyoming.
We're on third reading amendment number 1 to House Bill 7. Senator Anderson.
Yes, Mr. President, on and against the amendment. This takes the protections out that the citizens have asked for from some of these air ambulance services. They furnish a vital service to our communities, and sometimes they're not there because of financial problems and somebody else has to fill in. We need to know that their finances are in order. On and against the amendment.
Thank you. Senator Salazar.
Thank you, Mr. President. So first of all, I want to thank the Chairman of Revenue for bringing this forward. I know that in my county of Fremont, I was getting almost hundreds of calls from seniors, from people who wanted to once again be able to have that service for emergency healthcare purposes. This solves it. It's not perfect, but it is what my constituents in my neck of the woods, in my rural area want, which is to purchase again. And I think this does it. And I appreciate the chairman's openness to bring a number of different stakeholders to the table. This was a compromise amendment. It isn't perfect, but it solves, at least, I believe, the problem in my county for my seniors to once again be able to purchase that incredibly necessary service if they wish to purchase it. And so all those hundreds of phone calls that I got, and perhaps you got as well, this is an attempt to fix that, to mitigate it, and allow those people to once again purchase what they were able to purchase before April of 2020. Thank you, Mr. President.
Senator Scott, we're giving you your exercise this morning. One more time.
Mr. President, on and against the amendment. Mr. President, and I think that the bill as it stands right now is perfectly permissible under the federal law, that we're not regulating air ambulance service. We're regulating some of the insurance aspects of it, which we can do because there is another federal law, Mccarran Act, that allows us to investigate, to regulate those. And we do that. And in this case, one of the aspects we're trying to back off on the full insurance regulation, which is what we have right now. You've got to be licensed as an insurance company, and there is one that is licensed. We're seeking to regulate some pieces of that. And the financial solvency is an important one, Mr. President. It's not perhaps the most important, but it is an important one. And we ought to maintain that. And I think if we get taken to court, we'll win the case. But that's a matter we'll find out about if it's worthwhile. I think we may have a compromise here that will be acceptable to all the parties, I hope. So I would urge us to defeat this amendment.
Senator Ellis?
Thank you, Mr. President. I just wanted the body to know that I'll be declaring a conflict on this bill. My law firm does work with some of these particular service providers, and I didn't think it'd be appropriate to weigh in on the matter. Thank you, Mr. President, on the amendment or on the bill. Thank you.
Thank you, Senator. Senator Kinski?
Thank you, Mr. President. On and against the amendment, the real operative part of the amendment is line 1, which says delete the Senate Standing Committee amendment entirely. And what that wipes out is a requirement that these firms be able to demonstrate solvency, and then some other consumer protections, which I think places seniors and others who want to have this kind of insurance at risk. So I buy a health insurance policy, and my expectation is I'll pay my premium every month, but when I get that bill, that great big fat bill, that they're going to have the money to cover it. If you buy an air ambulance insurance policy and you pay the premium every month, the expectation is they're going to be solvent enough to show up when you need them. Now, what they do is they say, well, it's not health insurance, it's membership. Well, if it looks like a duck, walks like a duck, quacks like a duck, it's a duck. This is a health insurance policy that they're selling, and they should be able to demonstrate that they're solvent enough if you pay your premiums, your membership fee month in and month out, that when you need the air buggy, they're going to fly and come and get you. That's what you're paying for, and you deserve to know that they're solvent enough to actually show up. On and against the amendment. Thank you, Mr. President.
Thank you. Further discussion? Senator Rothfuss, go ahead, sir.
Thank you, Mr. President. On and for the amendment, and it's actually on and for the amendment with regret, to be honest. I want everything I just heard to be true and allowed and to work out. I want the original standing committee amendment to work and to be legal. I want the air service providers to be regulated by the state. I want the membership providers to be counted as insurance companies. I want everything we just heard. Regrettably, the courts don't agree. And so we don't get to have that. It's an 8th Circuit decision that is clear, unambiguous, and regrettable. And so when you read the decision, we just can't have what we construct just now as being a good thing. And it frustrates the heck out of me because remember, it was the Minerals Committee that worked this bill in the interim, and it was frustrating to work it and to have the folks come in and say, oh, we're not insurance companies. We're membership organizations. We're different. We have special rules, special privileges. You don't get to regulate us. It's awesome. And honestly, that was quite annoying to hear. And it gets back to the tall senator from Natrona County saying this whole thing for years has been a struggle for us because we can't find a way to wrap our arms around it and get anything done. The Minerals Committee put together a small, little allowable bit of regulation that helps provide a small, modest amount of legal consumer protection that is woefully insufficient, but actually will stand. That was the original bill. Everyone was okay with it. Not satisfied by any stretch of the imagination, Mr. President, but man, it was one of those bills that you pass it, you sort of feel like you didn't do all your work, but we did it anyway. The concern I have with the standing committee amendment is that it's more aspirational and it gets into territory that those of us on the committee that heard the testimony do not believe we can get to, and it will lead to the bill being struck down. And I don't want that. This third reading amendment restores it back to the point where I'm confident that what it does is allowed to be done and helps the folks in the community that are most benefiting from it right now. We've only really got one county, honestly, that is benefiting, or one community area that is benefiting well from a certain member agreement. And we want to make sure that at least any other member agreement has a bit of honesty associated with it. The bill in its original form is barely a step, but it at least is a step. If we don't pass this amendment, Mr. President, I'm afraid that we don't have anything at all at the end of this game. And again, I'll just reiterate, I would much prefer us to be allowed to leave the original standing committee amendment in place and in fact go a lot further. I believe their insurance. I agree with the good senator from Sheridan. My interpretation is, boy, it sounds an awful lot like an insurance policy that you somehow recategorized as not being an insurance policy so you could not be regulated. I don't know how that's not true, to be quite honest. I'm still struggling to understand that. Regrettably, the courts seem to agree that it's not true. So, Mr. President, on and for this amendment with regret, and I would encourage the body to pass this amendment and share my regret in passing. Thank you, Mr. President.
All right, a call for shared regret. Senator Case.
Mr. Chairman, Mr. President, I'm regretful too. Here's what happened. There were companies selling services that were very important to folks in central Wyoming, Fremont County, the Bighorn Basin, and it was a membership. We decided that they couldn't do that anymore, and there were problems. I give you that. I'm not arguing. We passed a bill that said you have to become an insurance carrier to do this and provide to all comers. It didn't work. One company did it, the other companies didn't. People's memberships came up for expiration and they contacted myself and my co-sponsor and said, please do something. Our membership's expiring. The company's telling us we can't do this. We know it's a membership. We in fact have two memberships. We have one to both companies. The town of DuBois, a benefactor, bought it for the entire town. There's a county in the Bighorn Basin where the entire county is covered by these memberships. They're going away. House Bill 7 worked very hard in the interim, brought them back. Brought them back. It's a big, thick bill. I don't like it. It's too thick. I like the different bill better. Brought it back. Made memberships possible. We got to the Senate and we weren't happy with that. We decided that we still were mad about the insurance issue. And we wanted to have financial viability. We wanted to have financial analysis from the Department of Insurance. Everybody seems to think that's a great idea. But this isn't a policy that pays, and if you don't have the solvency of the company, that you're going to have this lifetime of bills from your health care. It's not paying for your house to be rebuilt. It's just if your company goes belly up, you don't have to pay the $25 membership going forward. Means you're at risk on the air ambulance, of course. But these people actually know that they don't, it's one company, the other company might come. They understand it. And my constituents, my good colleagues, constituents, we hear from them. They want this to be back. They want to have their memberships. The disclosure that's in here is good. getting it from making sure that the Medicare people know that they are probably already covered, especially if they have supplemental. That's all good. That's all good. The amendment restores exactly the disclosure language and makes it work. I'm afraid if we don't pass it with this amendment, it's going to blow up, and we're not going to help those people that want to be able to buy memberships. It's just a matter of relaxing a little bit about the heavy hand of regulation. We can't make it perfect. It's a market relationships that's developed, it's used in other states. And Mr. Chairman, it works. It's not perfect. People do understand. And with these disclosures, we've made it better. Please support the amendment and the bill.
Thank you. Ready for the question? Question being called, House Bill 7, or excuse me, third reading amendment number 1 to House Bill 7 to the engrossed copy to the corrected copy. All those in favor say aye.
Aye.
Those opposed, nay?
No.
Nays have it. Division being called. All those in favor stand. $11. $17 no. Amendment has failed. We're back on the bill. Senator Landon.
Thank you, Mr. President. I appreciate the debate on the amendment. We touched on this issue a couple of times in our corporations committee the last couple of years. I know Minerals has worked on it. It would be helpful to me if that chairman might give us a quick overview real fast and tell us exactly where this bill is again. I tell you what I fear, and that is that boy, we've stood on principle, and there's probably even some law involved, and by golly, we're going to do this thing right. And meanwhile, we got a whole bunch of our Wyoming citizens now that probably aren't going to have air ambulance service. So that's what we take home, I think, with the bill as it stands right now. And I'm having trouble in my mind getting to a place where I can support this, because quite frankly, we've got a whole bunch of people in the rural parts of our state now who can't rely on anything. And we may, it just seems to me like we're running these companies out of our state because they're just not willing to put up with our state regulations. That gives me a little heartburn. And I guess I would like to understand if my perception of things is wrong, or maybe the Minerals Committee can help me by advocating for this bill. Maybe they can get me there. Thank you, Mr. President.
Senator.
Mr. President, relating to that concern, Mr. President, first, let's be very clear that we have nothing on the books that prevents air ambulance service. We can't do that. North Dakota may have tried that, but we have not. The question is, can they sell these quasi-insurance products that they call memberships? That's a different question from providing the service. Very different question. We passed that, the bill that limited the insurance part of this several years ago as part of another bill, part of a scheme to generally deal with that. It is clear we can do some things. At least I think it's clear we can do some things to regulate the memberships. Now, not everybody, not all the air ambulance companies sell memberships. ceased, it is clear that some of the ones that were being ceased were being sold previously, were being sold to people who could not use them, which is a disgrace. And that's something I think we can regulate. So the question is not service. The question is the selling of memberships, because they come whether you're a member or not. If the dispatcher calls them, they come. That's the business there. Then the question is there something in the bill as it stands right now that would cause the whole bill to be thrown out? And I would remind you, the provision in Title 8, Section 81103, BIII. If any provision of any act enacted by the Wyoming legislature or its application to any person's circumstances is held invalid, the invalidity does not affect other provisions or applications of this act, which can be given effect without the invalid provision or application. And to this end, the provision of any such act are severable. So we have a general severability clause. If we happen to lose on a suit brought over the issue on can we regulate the financial solvency to sell the memberships. So I think we're all right, but if the court says we're not, that covers us here with or without that amendment. So I think we need to be very clear that what the bill does is some modest steps to ensure that if you sell a membership, you can make good on it. Because it really is a form of insurance when you come right down to it. And second, get some restraint on the practice of selling things that you represent to be worth something but are not. And that's been the problem. And they misled a lot of people. It's quite a scam when you can, the people that are getting hit by it write in and complain about the stop being put to that. But that's what's been going on.
Senator Anderson.
Mr. President, yeah, we heard in committee, and this has been going on a long time. When I was in labor and health, we were working on air ambulance. And so that's 6 years ago. Every committee in this Senate has worked on air ambulance issues. So what we heard in committee was the complaint that these people paid memberships into this organization. And when it came time to come and get them, they were either out of business or didn't answer their phones or whatever. And somebody who did not take memberships came and got them. It isn't a matter that the air ambulance won't come and get you. It's a matter that you've paid these dues into these organizations. And when the time comes, they're not there for some reason. Now, it isn't always financial. It might be some other reasons, but the people that paid their dues wanted to have some sort of transparency on these organizations that they're paying their dues to. So there are quite a few of these air ambulances services in Wyoming that do not have memberships. They just come when they're called. So it isn't about everybody. Thank you.
Senator Nethercott, and then over to Senator Salazar.
Thank you, Mr. President. I think the good chairman of education and the chairman of minerals said a couple of things. One is a scam, and two, you buy something and then they don't deliver and you end up holding a very expensive obligation. Thus the need for us and our sister states to struggle with this issue and have continually worked on it, proffered up legislation and subsequently litigation. And I have to wonder if it's just not all for the lawyers in the end, but what my observation has happened, and of note, the #1 committee has never worked the issue. Perhaps it's time. That what happened was we heard a similar concern happening in our state that was happening in sister states. And so often as we do, and not inappropriately, but Sometimes conveniently, we look to who else has done this and who else has seen this before. Let's just do what they did. So that's what we did. And we never looked beyond for a different tool in the toolbox. We didn't look for the right weapon for the threat to our people in the state. And we picked up the wrong weapon. And we picked up the weapon or the tool or the solution for insurance. Wrong one. Hasn't worked anywhere, isn't working, continues to not work. The legal precedent coming out is that, yet we still continue to try to fit this square hole in a round peg, and it's not working, and we continually try to be surprised. So the issue really is the fact that federal law, the Airline Deregulation Act, trumps or preempts any state law as it comes to regulating an air service. True, this legislation in front of us in House Bill 7 is less restrictive or less prohibitive or less regulatory than our sister states. That doesn't make it any less unlawful. Our sister state banned the ability to sell memberships, and they also provided other type of regulatory prohibitions that came out in that 8th Circuit case. House Bill 7 is less, less serious than that bill, but it's still there. It's still a regulation, and it's still absurd. So if we look at page 1, in the very beginning, lines 1 through 7, and we go, what does this bill really do? It's very, very helpful to understand. An act relating to insurance. But wait, air ambulance service memberships are not insurance. I stop, but let's continue. Amending the definition of disability insurance, specifying that the regulation of air ambulance membership organizations and their memberships and plans is not insurance. Seems confusing? It is. Establishing registration requirements and regulatory standards for air ambulance membership organizations. Making conforming amendments and requiring rulemaking for the Department of Insurance to regulate air ambulance service memberships, which we clearly identify aren't insurance. So we adopted the semantics game of which they're playing. We're not insurance, you can't regulate us under insurance, and the good chairman of appropriations will explain why that argument is so effective, and why that argument is being postured, and why it's all a red herring. But the law has interpreted air ambulance service companies to be air service providers. Now, whether or not that's an appropriate interpretation, I don't know, but that's how it is. And it can't be changed with this legislation, and therefore we can't regulate them, because really it's not insurance, it's a membership, and we say it's a membership even in this own bill. So even though I believe that this bill is necessary and helpful, and I wish it was different, it's not, as the good senator from the ivory tower has indicated. I do believe that the bill is unlawful. I think it's ineffective. It's not the right tool in the toolbox. I do think that there's other ways to protect consumers in this state of these very critical memberships, but this isn't it.
Senator Salazar, go ahead.
Thank you, Mr. President. So I just want to relay a couple thoughts. And I guess I'm speaking to my constituents more than anyone. You know, the good chairman of Revenue and I saw the problem. We tried to solve it. I'm actually, I find it ironic. I'm actually more in support of those consumer protection provisions than you can imagine. Nevertheless, I know at the end of the day, what's most important for me is that my constituents, when they have a medical emergency, get air ambulance service. And once they are saved, what's the bill they get in the mail after they're saved? Now, someone correct me if I'm wrong. I believe there's only one company that is licensed by the Department of Insurance currently in the state that's providing this service. And I understand that those companies that were providing that membership are simply not selling any more new memberships. And I'm a little I'm a little angry. But I'm not going to go down that road right now. That's a different discussion. All I care about now is that my constituents have the ability to have that service. And by the way, I will tell you that there is a higher cost. There is a higher cost for that service, which is provided by that one company in the state currently. So all last year, when I was visiting folks at their front door, all I kept on hearing is, that's a higher cost. Why did you take that away from me when I had this previous service at a much lower cost and I was protected? And I didn't hear it just from seniors. I heard it from daughters and granddaughters and grandfathers. This is a problem that needs to be fixed. So I guess in conclusion, to my county, I have heard you. My good colleague from Lander has heard you. We understand the problem, believe me. And we will continue to do what we can to fix this so that you can have that type of service that you previously had. And I will say no, I won't say that. I will simply thank the Chairman of Revenue for being responsive to his constituents. And we will continue to fight on this issue, and appreciate the time. Thank you, Mr. President.
Senator Perkins.
Thank you, Mr. President, members of the Senate. Very reluctantly, because this is a big problem, very reluctantly on and against the bill. And let me explain why you should be against this bill too. Doesn't have anything to do with the intent, doesn't have anything to do with what it is, but simply we're providing a remedy that's not going to work. You've heard the good chairman of Judiciary talk to you about the fact that of this preemption. The preemption is because of the Airlines Deregulation Act. The Airlines Deregulation Act. They deregulated airlines, and that law is now that no one other than Congress has the ability to regulate airlines. Why is that important? Because ambulance services are federally licensed air carriers. Federally licensed, these ambulance services are federally licensed air carriers. That's why the Airline Deregulation Act applies. They don't allow states to go and regulate airlines because they've been deregulated by the federal government. Now, is there an exception in federal law that would allow states to come and do that? You've heard the mention of that. It's called the Mccarran Ferguson Act. And so the Mccarran Ferguson Act is a way that you can come and say despite other inadvertent federal preemption, the Mccarran Ferguson Act says that inadvertent federal preemption of state insurance statutes. So it provides states, it says if there's some inadvertent regulation of insurance by states, by federal government, then you can, it's a reverse preemption, then state law applies. Well, does that work in this case? Well, unfortunately, what we're finding is, no, it doesn't work. Why doesn't it work? Because what you have in these air ambulance is a subscription or club membership. Think of auto clubs. Think of, have you ever heard of concierge doctors, where you have a doctor and you pay a certain amount every month to the doctor. And then when you go see the doctor, you don't get another bill. You just pay this month, whatever it is, it doesn't matter. The doctor bill's already paid. Why? And you do that with some types of appliance warranties, not all kinds. Some of those are insurance, but what you're doing is you're paying for prepaid service. So you pay in advance, and then when you need the service, if you need the service, it's already prepaid, you don't get a bill. Now, these federal ambulances, in accordance with federal law, have to go, and our state law, they have to pick up wherever it is, regardless of where it is, regardless of their ability to pay, but it doesn't mean that they don't get a bill for their services. So we had a sister state that tried to do something very similar. They tried to regulate the subscription agreements and say that the subscription agreements were insurance products or similar to insurance products. And so therefore, they could do it because the Mccarran Ferguson Act would exempt that, and therefore we could do that. So if we come down and we just say, when is a subscription agreement or a pre-service paid agreement an insurance product? If we simply say it's an insurance product because we think it's enough like an insurance product that we can regulate under our commissioners, that's how we get around it. Unfortunately, that's already been tried and didn't work. So we had a sister state do this, and it came out of it was appealed that the air ambulance carrier prevailed in circuit court or in federal court, district court, is appealed to the United States Court of Appeals for the 8th Circuit. And guess what? They lost again. Why did they lose? Because the Mccarran Ferguson Act precludes, if the act specifically relates to the business of insurance. And so for it to be, it has to be the business of insurance. They've already said in the act, it's not insurance. It's insurance-like, but it's not insurance. This court, so the analysis that they went through, they looked at these subscription agreements. Isn't that what we're talking about, the subscription agreements? And so we're going to say they're insurance-like products, so we're going to do that. So they came back and said, you know what? This is what the circuit court said. They listened to all these arguments for the same ones we've heard about today. Subscription agreements here do not involve traditional state regulation of insurance companies, nor do, and so why don't they do that? Because although the subscription agreements transfer some risk from the subscriber to the air ambulance company, they are not insurance contracts. That's the statement of the court. They do not guarantee that this particular insurance company or an affiliated provider will provide services to the subscribers needed ambulance service or transport, nor do the subscription agreements require that the air ambulance indemnify the subscriber or make post-service provided payments to a third party.
Senator, your time.
If I can just go on, I'll be done. So I can use my second 5, Mr. Chairman.
All right.
And I'll be done. So the so anyway, the air ambulance insurance does not incur an insurance company's investment risk. They're not putting this money in and they're not pooling it and they're not using that. There's no surety in there. You're just prepaying for a club membership, just like an auto membership. Just like the good chairman from there, it's not you can't simply make it work like that. And so when it comes down to this, other states, not just this court, but other states and other federal courts, they simply look at these air ambulance memberships and they say that they're similar to auto club memberships that provide roadside assistance, to home and other extended warranties that cover the expense of repairing or replacing appliances or other items. The state's provisions seeks to regulate the relationship between a consumer and the air ambulance provider. They're simply prepaid agreements. And insurance, this happens all over the place, not just insurance companies, and therefore it's not an insurance product. And so Mccarran's not going to apply, and we're going to be in the same situation. We're going to pass this law. If somebody's smart, they're going to sue, we're going to lose, and we're going to pay money, and then they're going to be right back and we won't have done a thing. Don't give this false hope to don't give this false sense of security to our citizens. It's not going to work. We need to find the right tool. We need to find a different way. This isn't the way. Thank you, Mr. President.
Senator Scott.
Mr. Chairman, the lawyers are about to get me persuaded. And let me explain what I'm talking about here. If this bill fails, we have the existing law, which requires them to register an insurance department as and says it is insurance. And that's been the law for, we passed it, what, 2 years ago? And when the effective date hit, they declined to register and these things ceased to be sold. So if this was an attempt to compromise that, if that attempt to compromise it
has gotten us in trouble, maybe we're better off defeating this because that'll put us back to the existing law, which we have been able to enforce so far. And that may be the best course of action because that is the consequence of defeating the bill.
Let's go Senator Kinsky and then back to Senator Case. Let's do it that way. Senator?
Thank you, Mr. President. I rise to offer, as is my wont from time to time, a comment that's largely irrelevant to the merits of the bill. But it's germane, I think, to the Senate traditions of long standing. And part of that is there's usually these catchphrases that just perpetuate themselves from session to session to session. And yesterday, my colleague, the senator from the greater Dayton metropolitan area, used a phrase. He said, vote it up or vote it down. And I thought, what happened to that? We used to say that at least once a day in floor debate. And it's disappeared. That was the first time this whole session anybody had said that. And that's a famous Hank Coe-ism. It sounds profound, but is largely meaningless as to the impact on the debate. So I'm going to make it 2 days in a row, and perhaps the balance of the body can carry this tradition out through the end of the session. And I will say of this bill, vote it up or vote it down. Thank you, Mr. President.
Senator Case?
Mr. President, thank you. I want to urge you to vote for a bill that I hate. No, I'm going to tell you why. We screwed up last year, or the year before we did the other bill. There was a different fix. We didn't go with that. This is all we have. It's in the second house. There's an amendment. We have differences between our two houses. There is a chance. I have seen a bill rewritten on the floor. I think it was only yesterday that was amazing. We've got smart people. Let's not give up yet because this really is important to the people of the Wind River and the Bighorn Basins. It really is. It's not a false sense of hope. They know what they're doing. All we got to do is vote aye for the bill, send it to our good friends. They can vote down the conference committee or the vote down our changes. Some smart people get a chance to get together. And will it work, Mr. President? I have no idea. But I know that I don't want to go back home and say that I have absolutely nothing. You guys don't get it how our people, you live in bigger communities. Everybody that gets a toenail fractured has to be flown out. And they are afraid. And we may not be able to fix it. I'll give you that, okay? But the bill stays alive. We put together some of these really fine people that rewrote amazing things in the past couple of days. And we'd let them work at it. We got time left. Why not? What's wrong with it? Why not? So vote aye. Let the process work itself out. Let some smart people dig in here.
Senator Kolb.
Thank you, Mr. Chairman. This has been a big issue, I know. I think everyone's received those little the request to join some sort of service. And all the work that was poured into this and the frustration and to my constituents, their frustration. But at the end of the day, how can I stand and support something I know is flawed, fatally flawed? So I just want to thank the work that was put into this. And I'll close with saying, note to self, this doesn't work. Thank you.
Further discussion, Senator Anderson.
On and for the bill, Mr. President, I agree with the senator from the Wind River area over there. We've got to fix this. Maybe this isn't the perfect fix, but it's better than what we have on the books, and it'll get us a little further, and some smart guys can fix it. So let's pass it and get some more alternatives for our citizens. Thank you.
Further discussion, Senator Nethercott.
Mr. President, I'll work on trying to fix it. There's a lot of limitations with the catch title. Thank you.
Ready for the question? Question being called. House Bill 7, having been read 3 separate times, the question is, shall the bill pass? Chief Clerk, call the roll.
Roll call for House Bill 7. Anderson? Aye. Baldwin? Aye. Beitman? Aye. Boner? No. Bouchard? Aye. Case? Aye. Cooper? Aye. Driscoll? No. Ellis Conflict? Ellis Conflict. French?
Aye.
Aye. Murphy? Aye. Guru? Aye. Hicks? Aye. Hutchings? No. James? Aye. Kinsky? Aye. Cole? No. Cost? No. Landon? Aye. McEwen? Aye. Nethercott? Aye. Pappas? Aye. Perkins? No. Rothfuss? Aye. Salazar? Aye. Schuler? Aye. Scott? No. Steinmetz? Aye. Wasserberger? Aye. President Dockstetter? Aye. Closing vote. Closing vote closed. House Bill 7, 22 aye, 7 no, 1 conflict.
House Bill 7, having received the affirmative vote of the majority of the members elected to the Senate, House Bill 7 has passed the Senate. House Bill 46, third reading of the House Bill.
House Bill 46, Crime of Bestiality, sponsored by Representative Stiff, an act relating to crimes and offenses.
There is an amendment. Please read in the amendment.
House Bill 46, third reading amendment number 1, page 1, line 3, delete.
Senator Cost.
Thank you, Mr. President. I move third reading amendment 1 to House Bill 46 and ask for your favorable vote. What this does, the concern we had on Committee of the Whole was that maybe we need to consider a little more of a penalty such as felony when there's multiple occasions. So this does that. On page 1, line 3, it deletes a penalty and inserts penalties in plural. On page 3, line 5, after misdemeanor, insert for the first offense. Then on page 3, line 7, after both, insert bestiality is a felony for second or subsequent offense under this section or under a similar law of another state punishable by imprisonment of not more than 5 years, a fine of not more than $5,000 or both. With that, I would stand for any questions.
Discussion on the amendment. Questions on the amendment. Senator Hicks.
Mr. President, on and against the amendment. I often remember my days on judiciary where we were reminded over and over again, you put people in prison because you're afraid of them, not because you don't like what they did. This is a good way to drive the cost of prisons up, folks. Do you really think by putting somebody in jail for 5 years, it's going to reform them? The amount of money that you're going to spend incarcerating somebody for 5 years on this probably should have been redirected to maybe a little counseling, a little therapy. So you can spend $400,000 locking them up over the next 5 years. And guess what? Then we get to build a new prison for an extra $50, $60 million and hire new prison guards. This isn't the kind of crime that you throw people in prison for. You get them the psychiatric help that they need. This doesn't get us there. You put people in prison that you're afraid of. I don't know that I'm afraid of these people. I think they need help, Mr. President, on and against the amendment.
Further discussion. Senator Nethercott.
Thank you, Mr. President. To back up my good judiciary member, it's a great conversation that the Vice President mentions about should we be locking these offenders up. You know, certainly primary to this concern is their need for treatment. likely sex offender treatment of some sort, which they can get in the prison system. But I think it's important to be more pragmatic about the reality of the situation. So the amendment has no more than 5 years. As a result of that limitation and as a result of the time that someone's probably going to spend on bond, it's unlikely, possible, but it's unlikely that the court would sentence them to the correctional facility due to the short amount of time that they would be there. It's just too short of a time because they get good time. So a defendant only really serves about 2/3 of the time that they'll get. I doubt that they'd get the max of 5 years. So the 5-year limitation really prohibits the ability to do any kind of meaningful incarceration, and everyone knows that in the system. What the amendment does do is it creates it a felony conviction. That's really the policy question, I think, to consider is whether or not a subsequent violation of this particular crime should be a felony. And, that's the policy question for the body to consider. Additional facts associated with that is, what is the likelihood of other deviant behaviors that are harmful to the public and harmful to the community from these types of crimes? Because usually this type of conduct is not limited to animals. And so it can be beyond that. And those are certainly concerning facts, but it's a policy question for whether or not you want to make a subsequent offense a felony. Again, I think it's unlikely that a defendant would go into the prison system, but it's possible.
Further discussion, Senator Kinsky, then to you, Senator Scott, sorry.
Thank you, Mr. Chairman. On and against the amendment for, again, reflecting my service on judiciary. I remember initially I didn't really want to go on judiciary, and I called a friend of mine in the northeast corner of the state. He's an attorney, and he actually just finished up service as Speaker of the House. And he said, "Oh, you should go on judiciary. We need people who know how to say no." And I said, "Say no to what?" And he says, "Well, what you get in judiciary is just a constant parade of offenses and horror stories and terrible things that have happened. And as they come through, people are so aghast and often with good cause that he said, everybody wants everything to be a crime and they want everybody to go to prison forever for it. And he said, pretty soon you end up with really no equity in your sentencing structure because bills keep coming through and this is a felony, this is a felony, this is a felony. He said, you'll have somebody sitting in a jail for attempted homicide next to somebody that's in jail next to somebody for some crime that's far less offensive. And he said, there's just no equity in the system. So when we pass these penalties like this in a patchwork, it moves us closer towards probably having to do another haul of the criminal code, which I think the senator from Bates Creek told me the last time that happened was a quarter century ago. And we may be overdue to that, to go back in and look at all the sentences for everything and try to get some kind of equity in the sentencing. But I can tell you, when you elevate this one to a felony status, you're putting it on a par with crimes that likely you would consider far more serious. So on and against the amendment, let's keep the bill as it is and keep it moving on its merry way. Thank you, Mr. President.
Senator Scott.
Mr. President, the last time we did a full overhaul on the criminal code, looked at all the sentences, I believe was 1982. There've been some partial ones since then. Mr. President, on against the amendment, we've got way too many felonies. And Mr. President, I think it's time we stopped creating new ones. So I'm going to call for the yeas and nays. And as you vote, the people that get convicted of that, they have a mental illness problem. At least that'd be my judgment. Anybody would do anything like this. And I think the question is, what's the best way to get them rehabilitated? And I think convicting them of a felony where
Let's keep it down for the person speaking. Thank you.
Convicting of a felony where that locks them out of so many kinds of employment, has so many other consequences, is not going to help with the process of rehabilitation here. And I think that it's much better to keep this in the misdemeanor category. I think going to the felony interferes with what we really ought to be doing, which fortunately is very rare, but getting them the mental treatment that they need.
Further discussion, further discussion. Ready for the question? Roll call on third reading amendment number 1 to Senate File 46. Chief Clerk, call the roll.
Roll call on third reading amendment number 1. Anderson? No. Baldwin? No. Beitman? No. Boner? No. Bouchard? No. Case? No. Cooper? No. Driscoll? No. Ellis? No. French?
Aye.
Aye. Murphy? No. Guru? No. Hicks? No. Hutchings? No. James? No. Kinsky? No. Cole? No. Cost? Aye. Landon? No. McEwen? No. Nethercott? Aye. Pappas? No. Perkins? Aye. Rothfuss? No. Salazar? No. Schuler? No. Scott? No. Steinmetz? No. Wasserberger? No. President Dockstetter? No. Closing vote? Closing vote closed. On the amendment, 4 aye, 26 no.
Third reading amendment number 1 to Senate File 46 has failed. We're back on the bill. Further discussion on House Bill 46. Are you ready for the question? Question being called. House Bill 46 having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Roll call on House Bill 46. Anderson. Aye. Baldwin. Aye. Beitman. Aye. Boner. Aye. Bouchard. Aye. Case. Aye. Cooper. Aye. Driscoll. Aye. Ellis. Aye. French.
Aye.
Aye. Murphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. James. Aye. Kinsky. Aye. Cole. Aye. Cost. Aye. Landon. Aye. McCown. Aye. Nethercott. Aye. Pappas. Aye. Perkins. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Steinmetz. Aye. Wasserberger. Aye. President Dockstetter. Aye. Closing vote. Closing vote closed. House Bill 46, 30 aye.
House Bill 46 having received the affirmative vote of the majority of the members elected to the Senate, House Bill 46 has passed the Senate. House Bill 58, third reading of the House Bill.
House Bill 58, State Parks Account Expenditure Authority, sponsored by the Travel Committee, an act relating to state lands.
There is an amendment, Senator Perkins. Oh, read in the amendment, please.
House Bill 58, third reading amendment number 1 to engrossed copy, page 2, lines 6 through 10, reinsert.
Now, Senator Perkins.
Thank you, Mr. Chairman. Mr. President, I'd move third reading amendment number 1 and ask the body to vote aye. Mr. Chairman, what this does in state parks is it's important to understand what happens with the fees that are collected from state parks and what this bill does. And what this amendment does is simply say what we're doing will go on for the next 2 years, and it goes back the way that it was. That's what the amendment does. And the reason I think that's important is because what you had before is you have this enterprise, sometimes called the enterprise fund, but it's a special revenue fund which consists of the fees that come out of the parks and the parks collect. And the legislature, that's a special revenue fund. And the legislature's always used, there's been a certain amount used for maintenance. Up to 25%, usually sometimes more, has been used for capital construction. Legislature always gets a chance to look at that and approve those capital construction projects. And then it's used for, used for other purposes to defray some of the general funds that go into the State Department or the Department of Parks. And so when we change this and what we're doing is we're doubling the amount of these special, and this can be substantial, particularly during the pandemic. We've had some banner years in state parks and state campgrounds. And so what this does is say, instead of using this 30 for maintenance on existing facilities, we're now expanding it so it can be used for maintenance and operations. And fair enough, there is, with what that means is we continue to do the maintenance, but there's more that's available for temporary employment of individuals. And with some of the influx we've had, as we've heard about it, if you've ever been to Glendale or some of these parks on the weekend, it is amazing what happens in those facilities. And so, you know, certainly with the operational, they can they can use this to hire temporary employees, they can hire temporary security, they can do other things to help get this taken care of, and particularly during the pandemic. 2 years gets us, I believe, through the pandemic. We'll have an opportunity to look at that and see if we want to continue to do that. But in addition to just temporary employees, it also provides them, the department, the ability to hire AWACs, which are at-will contract employees, which are not full-time equivalents, but like I say, they're at-will employees under contract. And so there's no restriction on how much and what they do. And one of the things I think it's important for the legislature to do is monitor what happens with personnel positions and what we're doing with respect to workforce and why it's there. And so this basically gives them the ability to do what they need to do in this kind of uncertain time for 2 years. And we'll take a look at it. At the 2 years, it'll sunset. And if we think it's worked out well, we can lift the sunset at a later time. We'll certainly have an opportunity to take a look at it in the budget in the coming year and hear testimony and make those adjustments. But that's what the amendment does, and we urge you to do it so that we can just keep an eye on this and make sure that it's being used appropriately. Thank you, Mr. President.
Further discussion on the amendment? Questions on the amendment? Ready for the question? Question being called. This is on third reading amendment number 1 to House Bill 58. All those in favor say aye.
Aye.
Those opposed, nay. The amendment has passed. We're back on the bill, House Bill 58. Any discussion on the bill? Are you ready for the question? House Bill 58 having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
House Bill 58, roll call. Anderson. Aye. Baldwin. Aye. Beitman. Aye. Boner. Aye. Bouchard. Aye. Case. Aye. Cooper. Aye. Driscoll.
Aye.
Aye. Ellis. Aye. French.
Aye.
Aye. Murphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. James. Aye. Kinsky. Kinsky. Aye. Kolb. Aye. Cost. Aye. Landon. Aye. McEwen. Aye. Nethercott. Aye. Pappas. Aye. Perkins.
Aye.
Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Steinmetz. Aye. Wasserberger. Aye. President Dockstader. Aye. Closing vote. Closing. Vote closed. House Bill 58, 30 aye.
House Bill 58, having received the affirmative vote of the majority of the members elected to the Senate, House Bill 58 has passed the Senate. House Bill 73 for third reading of the House bill.
House Bill 73, birth certificates, gestational agreements, sponsored by Representative Greer, an act relating to vital records.
There are amendments. Please read in the first amendment.
House Bill 73, third reading amendment number 1 to engrossed copy, page 2, line 19, delete.
Senator Case.
Thank you very much, Mr. President. I would move third reading amendment number 1 to House Bill 73. Mr. President, what this does is brings in some of the language in this into the real world. Kind of match our parent and adoption statutes with what the surrogacy has. So what it does, Mr. Chairman, is Mr. President, is it goes into page 2 and lines 18 through 20, talks about the gestational agreement. Current proposal says it means a written agreement between 2 intended parents and a gestational carrier. I'm saying the intended parent and the gestational carrier, because it could be a single person. Under statutory construction, the word parents with an S can be a plural or a singular. It's not multiple, but it would be between the intended parent, and the gestational carrier. So one person can be a parent under our law. One person could become a surrogate parent. Turn to page 4. It's the same language on lines 5 and line 7, where we remove 2 and put the word the. And on a separate issue, Mr. Chairman, and it is dividable, Mr. President, on page 4, down at the bottom of the page, the section E, it says, upon the birth of a child under a gestational agreement, the intended parents of the child born under the gestational agreement shall be deemed to be the mother and the father of the child. It's a new world. Same-sex parents do adopt children. We even have one as a member of this legislature. I've been so impressed with that family, Mr. President. I don't think we should have this sexist language in our law. So this would change it to be, the agreement shall be deemed to be the parents of the child. It's that straightforward of an issue. It matches up with the rest of our law. It gets rid of the sexual reference or the notation of the sex of the parents. So I'd ask for your favorable consideration. The amendment is divisible. If you want to deal with a single person having becoming a surrogate parent, anyway, it is divisible. So thank you, Mr. President.
Senator Nethercon.
Thank you, thank you, Mr. President. I would just say, I know the bringer of the bill, the sponsor of the bill, and the issue itself concerns the biological parents of the child. So where there's an embryo created and implanted in another woman, and so who's just the surrogate. So just kind of a point to step back and understand the parameters or the circumstances of which it's intending to address. And it's not really intending to address adoption. In fact, it's trying to avoid adoption by having the actual biological parents, which requires a male and a female, to do that. Not trying to get into the politics of that, just the reality of it, to create that child. And so the two biological donors, the two biological parents of the child, that's what the bill is trying to do. Point of history and clarification and background.
Further discussion? Senator Rothfuss.
Thank you, Mr. President. But to clarify the amendment, I see the point of the bringer in that those references are not to the biological parents, which can clearly be mother and father. And the concept of two is, again, not the biological that are being referenced. It is the parents that will be the receiver, we'll say, of the contract and end up being the parents. So the amendment would need to be in place to achieve that, Mr. Chairman.
Further discussion? Back to you, Senator Case.
Mr. President, let's talk biology here. I'm a little bit out of my realm. So we think of sperm and an egg from two different people. I don't know what's going to happen down the road. You could certainly have the sperm from a male person that might be a donor sperm, it happens all the time. It could be a donor egg, but people that won't be the parents of the child. But yet the parents of the child could be a same-sex couple. It could be, and these aren't the biological parents. These are the people that are going to raise the parents. There may be some piece of the biology from one or the other. Down the road, it may be both pieces. I don't know. But it conforms to what's happening now. in the adoption world. And, you know, you have all sorts of couples that raise children together that are same sex, where the child might be the biological product of something that happened in the past with one of them and the other one adopts. It happens all the time. And this recognizes that we don't need this language about mother, father in our law to move forward. Thank you, Mr. President.
Any further discussion? Ready for the question? We are on third reading amendment number 1 to House Bill 73. All those in favor say aye. Aye. Those opposed, nay. No. The amendment has failed. Division being called. All those in favor, please stand. Ten in favor? $19. The amendment has failed. Reading clerk, reading the second amendment.
House Bill 73, third reading amendment number 2 to engrossed copy, page 3 after line 22, insert.
Senator Steinmetz.
Thank you, Mr. President. I'd move third reading amendment number 2 to House Bill 73 and ask for your favorable consideration. Fellow senators, this is what we were working on yesterday, and thank you for defeating my good amendment. We're just adding a few words to it today. So we're adding section G. Compensation is limited to expenses related to prenatal care, delivery of the child, and any other costs, including the cost of lost opportunity that are directly connected to the pregnancy. This contemplates someone who may be having difficulties going to work or something like that. And this amendment provides some protection for women. We didn't want to see them, you know, it being a financial motive to do this kind of thing for folks. And so it just kind of takes the compensation part component out of this. So I'd hope you'd support this amendment today.
Further discussion on the amendment. Let's go to Senator Perkins, then to Senator Nethercott.
Thank you, Mr. President. You know, this certainly isn't perfect, but I think it's helpful. The concerns we had yesterday is, I mean, I think, Mr. President, it's important to take one step back and look at the purpose of this bill. The purpose of this bill is to simply, what you have is simply the opportunity to, that you have the father with his donation to this process, gets to be on the birth certificate, but the mother whose eggs are donated to this doesn't necessarily, in the usual gestational agreement, not all, but the mother's contribution is then somehow not equal, and ultimately the mother's egg, it's not the mother's egg, but the surrogate mother who's listed on the birth certificate. So this whole thing is to try and create an opportunity for this to be recognized and get through this with birth certificates, recognize what the intent is and what the desired outcome of all the parties were initially. And so that's the purpose of this. And then, but there's some concerns have arisen about how do you avoid, you know, how do you help women from being exploited if they're down on their luck, or other issues from being kind of trapped or otherwise taken advantage of in the surrogacy. In my mind, that's a secondary issue, and this is trying to deal with that. So ultimately, and the reason we have lost opportunity cost in here is I don't know how all of you are, but in my family with some pregnancies, they started with very shortly and went all the way through the 9 months, and people couldn't work. You know, so the surrogate mother may have planned to work for the first 8 months and then not worked. And so we wanted to make sure that this person could be compensated. On the other hand, you don't want someone to come in enticed with more money than anybody's ever seen to do this, and maybe they get taken advantage of. So the important here is just trying to recognize that there are some opportunities that may be forgone or lost And so to make sure that those types of costs can be rewarded. So if somebody couldn't work for a period of time, they can be rewarded for that work. They can get compensated for that. At the same time, trying to leave it open enough so that we don't have this heavy hand of overregulation get too crazy in this whole thing. Just trying to find, it may not be exactly, but I think it helps and opens up the door for this to be equitable to everybody. But hopefully we'll avoid some of the concerns about abuses. And I hope that we can support this because I really think this is secondary to the purpose of the bill. But it is an important secondary consideration. Thank you, Mr. President.
Senator Nethercott, did you stand?
Yes. I'm wearing bigger shoes today. Mr. President, thank you. And I, hesitated to even speak. I think it's been addressed by the Chairman of Appropriations and the bringer of the amendment. I've been a bit confused about this issue because really the small amount of pushback I think we've heard on the bill is related to this grave and overwhelming concern about the vulnerability of these women who would be surrogates, and are they being preyed upon, and are we turning babies into products and commodities? And I just have been a bit perplexed at the dramatization of that characterization of what's occurring in the state. Just in my practice and in observation and in life in this community, most typically these are middle-class folks who have struggled with having a child and go through an extensive and laborious and costly process of IVF to create an embryo to then implant in another woman. And as a result of all of that effort and out of all of that desire to find a surrogate mother, I don't think that they're looking for the vulnerable women to exploit who are not capable of making good healthcare decisions for themselves and aren't receiving adequate healthcare. And so I think that this concern for the exploitive nature of turning this into some type of harmful thing for the women of our state is well-founded, but not a real concern. I think the women of our state can make those decisions for themselves, and those couples who are seeking a surrogate are most commonly relying on family members and others very close to them for these services. And if they were to find someone who was not a family member or a dear friend, I think they would be very cautious and very careful about who they would select to carry their child. So the concern about the commoditization, I think, is unfounded, and I think that this amendment helps address those concerns, although unfounded.
Further discussion? Ready for the question? Question on third reading amendment number 2 to House Bill 73. All those in favor say aye. Those opposed, nay. Ayes have it. Third reading amendment number 2 to House Bill 73 has passed. Back on the bill. Any further discussion? Question on the bill. House Bill 73 having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
House Bill 73, roll call. Anderson. Aye. Baldwin. Aye. Beitman. Aye. Boner. Aye. Bouchard. Aye. Case. Aye. Cooper. Aye. Driscoll. Aye. Ellis. Aye. French.
Aye.
Aye. Murphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. No. James. Aye. Kinsky. Aye. Holt. Aye. Cost. Aye. Landon. Aye. McEwen. Aye. Nethercott. Aye. Pappas. Aye. Perkins. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. No. Scott. Aye. Steinmetz. Aye. Wasserberger. Aye. President Dockstader. Aye. Closing vote. Closing. Vote closed. House Bill 73, 28 aye, 2 no.
House Bill 73 having received the affirmative vote of the majority of the members elected to the Senate, House Bill 73 has passed the Senate. Mr. Majority Floor Leader.
Mr. President, I move we stand recessed till 2 p.m.
Heard the motion? All those in favor say aye.
Aye.
Those opposed, nay. Oh, you had one, but we just moved out of.
We just too late.
Too
Too
late
late.
now. I had referrals
You
to
catch
do
us
that.
just as soon as we come back, sir.